Hello and welcome to the Legacy IAS. So today we are going to discuss a topic that is much more controversial if we discuss, because here you will get only those either they support it or they oppose it. You will not get the individuals, those who can take the middle path. So here we are talking about the reservation. So it is the news is that Supreme Court says that Parliament must decide on reservation quota reform. That means here Supreme Court is directing the Parliament, directing the legislature, the government, that to bring a reservation reform. That means there must be a reform in the reservation. So we will discuss, for example, first post same on caste based quota. Supreme Court says 75 years of benefits enough. ये सुप्रीम कोर्ट ने बोला है कि 75 years of benefit is enough. Now we need to bring some reform. Reform मतलब उन्होंने कैसा बात किया है, I will tell you. The thing is this: if someone has already taken the benefit of reservation, then that person should not get reservation benefit again. There are other individuals in the same community, they have not received this reservation benefit ever. Now they should get the opportunity for the reservation. This is what basically told by Supreme Court to the Parliament. So we will discuss one by one all those things. So first is this historical context of reservation. If we check, so reservation was introduced post independence, basically in 1950 only, to SC and ST as well as OBC, but OBC has received reservation only in 1992 after implementation of Mandal Commission report. Clear? So reservation SC and ST they are getting already earlier since 1950. OBC 1992. They basically promote social justice and equitable representations in public sectors, education and employment. That is the cases. And 75 years of affirmative actions aimed at the reducing socio-economic disparities. Now we will check what are those constitutional provisions where we will get reservation. Okay, article numbers. So you can check it. There is article number 15.4. It talks about reservation. And especially here we give reservation in education, basically the admissions in the colleges, in the IIT, all those. And article number 16.4 basically talks about reservation in public employment, that means public employment opportunities. Article number 46 it talks about directive principles of the state policy, जहाँ पे फॉर एग्जांपल स्टेट को इंस्ट्रक्शन दिया गया है that they need to improve the living standards of the this community like SC or ST or disadvantaged community. And article number 335 talks about the claims of SC and ST, basically if they are claiming. So that is all about is. So one more जो एक हम आपको misconception बता रहे, that is myth. Myth is this: many of the times it is quoted that Baba Sahib Ambedkar, when he has introduced the reservation, at that time he told that reservation will continue only for the 10 years, and after that politicians they keep increasing this reservation time period. The thing is this 10 years time period that you are talking about, that Baba Sahib Ambedkar has implemented it, it was not for the reservation in education and public employment. This was basically reservation in legislature. Like example, in parliament, especially I am just leaving Rajya Sabha, like in the Lok Sabha, like in the, for example, a state legislature, the seats are reserved for SC and ST community but not for the OBC. So here 10 years time period Baba Sahib has given only for those reservation in legislature, but this 10 years time period is not given under article number 15.4, under article number 16.4. That means there is no time limit of 10 years that most of the individuals they claim it. It is completely a myth. Now we move to another category. So reservation percentage अगर हम देखें तो reservation is available to ST, reservation is available to SC, OBC and EWS category. So for example, if we check it, reservation ST, okay, community, so they get reservation around like 7.5%, SC community get 15%, and OBC get like 27%, and after this 2019 के बाद EWS economic weaker section they got reservation around 10%. अब हम लोग आगे बढ़ते हैं. फॉर एग्जांपल सुप्रीम कोर्ट ने क्या रूलिंग दिया? सुप्रीम कोर्ट हैज गिवन दिस रूलिंग ऑन बेसिकली जनवरी 10 2025 रिसेंटली ओनली. जस्टिस बी आर गवई एंड जस्टिस AG Masi. Justice B R Gavai, he is a basically Dalit, okay, judge of the Supreme Court. So his statement is this: Supreme Court expressed that individuals who have already availed the benefits and are capable of competing independently should be excluded from further reservation. I told you this. This was a statement that is given by the Supreme Court. Like for example, here if you got the reservation, correct him, and through reservation you got the college admissions also, and through reservations you get the job also. Job in the sense, like example, you have cleared the state PCS exam, now you became SDM or deputy SP. Now after that your family or your other individuals जो आपके family में आएंगे और your children, they should not get the benefit of reservation, because now you are capable enough that your child can compete basically, they can compete now in open category only. But in your own actually community there are other individuals are there, those who have not received any reservation, now they should get the reservation. That is what actually told by the Supreme Court here is. But ये बोला लगा है कि यहाँ पे we need to define कि which type of public employment should be considered as an exclusion. Like example, if one individual through reservation he got the job of like peon or sweeper, अब definitely this guy or his family definitely deserve a reservation again. But agar if some guy he has got, for example, okay, class A or class B job, and then this guy's family does not deserve basically the reservation, because there are other individuals members are there in the same community like SC or ST, those who have not received reservation ever, now they should get this fruit of reservation. This is what reform it was discussed by Supreme Court here is. तो सुप्रीम कोर्ट ने बोला रिस्पॉन्सिबिलिटी किसको दे दिया है कि लेजिस्लेटिव एंड एग्जीक्यूटिव बॉडीज टू डिसाइड ऑन पॉलिसी इंप्लीमेंटेशन. दैट मींस now it is the job of parliament, it is the job of state government, the job of state legislature to formulate the policy to implement this idea or to implement this quota reform. Now next is, for example, यहाँ पे हम we are going to discuss about one old case of 2024, especially in the August month. In August 2024, in Supreme Court, one of the judgment here we call that sub classification of SC, that is scheduled caste. Here Supreme Court has allowed the state means like Andhra Pradesh, Karnataka, Uttar Pradesh, here allowed the state to create sub classification within SC ST category for fixed sub quota. Like example, अभी SC के लिए there are around, for example, 7.5, this SC के लिए around 15% seats are reserved, correct? Under SC also there may be few communities, like example community 1, community 2 and community, many communities are there, but community 1 जो है ना, it is more disadvantageous compared to community 2 and community 3. For example, I will tell you the example of Meena in Rajasthan. If you take the, for example, any year of result of the UPSC, for example, civil service, then if you just search Meena, you will get around 26 to 30 individuals from the Meena community only. Every year they got selected. But whatever other actually other caste on that same community, they are not getting any benefit. The same way यहाँ पे like example, if community A under SC, they are more disadvantages. Out of 15, some portion must be fixed for that particular community only. This is what Supreme Court says, that state can do this. Earlier it was thought that state cannot do sub classification under this SC category or ST category, but in 2024 Supreme Court made clear by 6-1 judgment. By 6-1 judgment, it was headed by basically CJI DY Chandrachud. It was headed by CJI DY Chandrachud. यहाँ पे उन्होंने बोला ऑब्जेक्टिव क्या था, ensure equitable distribution of reservation benefit to the most backward community. Understood or not? And here actually they have overturned earlier decisions, overturned precedent. Reservation 2000, they have actually overturned 2004 EV Chinaya ruling that considered SC ST as homogeneous group. There was one case was there in 2004, EV Chinaya versus state of Andhra Pradesh in 2004. यहाँ पे for example सुप्रीम कोर्ट ने बोला था कि you cannot do sub classification under SC and ST category, but here in 2024 in August, Supreme Court by 6-1 ruling says that you can do sub classification under SC and ST category. See, 1975 in the 1975, Punjab government has tried to sub-classification under SC and ST category. Like example, for Balmiki, for Majhabi Sikh, for these basically disadvantageous groups under Sikh community, they were given actually a fixed quota under SC basically, but it was overturned here under 2004. State cannot do this, but in 2024, Supreme Court has overturned this judgment and told that or given direction that states are allowed to do sub classification. Clear this? Next is, but state has not implemented yet sub classification of SC. So I told you this, this was the case in 2024 ruling. A 7-judge constitutional bench majority is 6-1 allowed sub classification within SC, that is scheduled caste. Objective क्या था? Ensure benefit reach the most disadvantaged sections within SC community also. Basis ये था sub classification on identifiable and demonstrable socio-economic data. That means through data, through fact, you can do this sub classification. This is what the Supreme Court's ruling is. Now, impact इसका क्या होगा? Legislative implications क्या होगा? Role of legislature required to create a framework for identifying and excluding creamy layer beneficiaries within SC, that is scheduled caste. That means अभी अपने यहाँ क्या present condition is this, we are having creamy layer concept only in case of OBC category, but it is not for SC and ST category. There is no creamy layer concept under SC and ST category. इसका मतलब क्या होता है कि for example if एक SC community family is there and that family's annual income is like for example 1 crore rupees. I am just giving the example. There is one SC family is there and this SC family's income is around 1 crore per annum. Now this family's child if want to attempt UPSC exam, this child will get the benefit of reservation even though his family income is 1 crore rupees. That is what because there is no creamy layer concept under SC category or ST category, but in OBC there is a creamy layer concept is there. That Indra Savaini case, if you must have heard, under Indra Savaini case Supreme Court has fixed that there must be a creamy layer concept. So same way Supreme Court given direction कि legislature need to create a framework to identify this creamy layer beneficiaries within scheduled caste. Delay in policy formulations, I told you 6th month after ruling, that means August 2024, 6 months already have been passed. No comprehensive policy has been framed by the state because states are having fear. They are having fear that if they are going to actually do some reform in the reservation, then the community which is going to lose this benefit of reservation, they will not going to give them vote. Now next is creamy layer concept. I told you what is the definition is. It referred to the individuals within reserved category who have attained socio-economic advancement. Existing applications. So currently this is applied to the OBC only, potentially extension to SC and ST. That means we can extend this concept to the SC and ST also. Now if we come back, what is the challenge for the implementation of this policy? So delay in action, state they are yet to frame any policy despite Supreme Court directions. Social sensitivity because concern over backlash from marginalized communities regarding proposed exclusions because they are the vote bank also. Correct? So ultimately through reservations, maximum benefit has been received by the politicians only, not by the individual. Here I am saying this line through underline only in bold letter. Administrative complexity क्या होगा? Difficulty in identifying and categorization beneficiaries under new reform because it is not possible to identify the framework to the factors. Along with those factors, we need to identify who will come under creamy layer, who will not come under creamy layer concept. Another important is future directions क्या हो सकता है? So future direction is this recommendation for policy development. That means whatever the policy reform we need to bring, it should be data driven identification of beneficiaries. That means through census we need to know. Focus on creating inclusive framework for equitable access. Stakeholders engagement means we need to discuss with the communities, their leaders about this reform, and need for clarity. That means transparent communication to build public trust and ensure smooth implementation. This is what basically was today's discussion about this reform in reservation. Now you have to comment what reform you need in the reservation, whether reservation is needed or is a need of the hour, or we need to bring any reform, or it should be abolished. What is your comment? You have to discuss in the comment section. If you are new to the YouTube channel, please subscribe and don't forget to like this YouTube video. Thank you.